the focus of my lecture are initiatives from the Supreme Court on environmental activism. And I focus here on three things. One is the Oposa decision. The second one is MMDA on the cleanup of the Manila Bay. And third is the environmental rules for litigation. I keep getting the acronym mixed up. Now, Oposa, I know, excites a lot of us. And um, the reason may be a little misplaced. But if you examine the literature on this topic, you will find out people tend to say that the Supreme Court recognized standing for future generations and that it halted logging. And in a moment, I will demonstrate why. I mean, we all know that's not exactly true. Neither one is exactly true. But I'm here to talk about these three areas and to talk about why it might not be achieving the goals that the Supreme Court had in mind when they took these steps. Now, we're famous, thanks to Tony Oposa, because he's been filing all these cases, right? So in 2009, that's when the Manila Bay case came up. We were introduced to continuing mandamus, I think, which was derived from the Brown case in the United States, desegregation. And then in 2010, we have the rules on procedure for environmental cases. And in that set of rules, the most famous remedy that we have right now is the writ of Kalikasan. Okay. And that's my thesis. I may seem dark, but things will lighten up before this day ends. Okay. The remote kasi the Supreme Court's role in protecting the environment works even if we have a separation of powers, right? Those are lawyers, a little review. And under the separation of powers, we know that Congress legislates, the executive executes the law, and the judiciary interprets the law. And then they are supreme within their own spheres and are not allowed to interfere with the functions of the other branches of government. The exception, of course, is when they act as a check on the other branches of government. And judicial review, as Attorney Nisser pointed out, I would have gone with nicer. Why? Nisser doesn't make any sense. Nicer makes a lot of sense. Attorney Nisser explained that we have judicial review. And unlike the experience in the United States, where there is no constitutional basis for that power, we have a very clear provision under the 1987 Constitution, giving the Supreme Court power to check the work of both the legislative and executive branches of government. And under that scheme, the function of each branch of government is limited. So insofar as the judiciary is concerned, it cannot second-guess, in effect, the work of the executive branch of government. They cannot be smarter than the executive. And they cannot legislate, no matter how bad the laws are. Their function only really is to ensure that the function of these two branches of government are not violating the strictures of the Constitution. So that's one way the court is able to participate in environmental protection, judicial review. There, and under our Constitution at present, it has expanded. Come on, technology there. And you know that the Supreme Court has expanded certiorari powers. If you're not a lawyer, bear with me. And has been given the power of judicial review, including the authority of the regular courts to determine in an appropriate action the validity of the acts of political departments. And here it is. Expanded jurisdiction to review the decisions of the other branches of government, branches and agencies of the government to determine whether or not they have acted within the bounds of the Constitution. And those of you who are familiar with the Philippine legal history know it was inserted there so that the executive branch can no longer rely on the political question doctrine. So now, even if it is a discretionary function of the political branches of government, the Supreme Court can step in, if there is a proper case, to determine if you exceeded, right, your functions. They can still tell that you may have performed your functions, but you exceeded that power, and you acted with grave abuse of discretion, acted whimsically without basis. Okay. And that is the Supreme Court, the Constitution's, the text of the Constitution now. So unlike the U.S. Constitution, in the U.S. they're still arguing about whether judicial review is constitutionally permissible. We have no choice. It's right there. So, they can review the acts of the executive department, etc. Sayang ang special effects ko. Late. The other way, of course, the Supreme Court can participate in the protection of the environment is by exercising its rule-making authority. Okay? And under the 1987 Constitution, the Supreme Court was given power to write rules for the protection of constitutional rights. And therefore, the court correctly, I think, exploited that provision, or used that provision. Exploited is so loaded. Used that provision to implement the environmental rules. That's where we're introduced to writ of kalikasan. Right? And there are so many the court can write rules, including practice of law, practice of procedure in all courts. But for this afternoon, our concern really is protecting the environment. So since it is a constitutional right, the Supreme Court has that power now to issue the procedural rules. So that's the constitutional framework that explains how the court steps into protecting the environment. And the Supreme Court says this is the effect of the expansion of the rule-making authority of the Supreme Court under the 87 Constitution. Most particularly, no longer sharing the power with Congress to govern practice of the profession. So Congress can no longer tell or interfere in who passes the bar exam or not. Right? It's just completely, exclusively a function of the court now. All right. Bosa versus Vactoran that put us on the map of environmental law. Now, I have been saying this for 3 decades now, and I'm pretty sure some of you might disagree, but I assure you I'm right. The Supreme Court did not recognize standing to sue because standing was not an issue. Because Secretary Vactoran did not say that the children did not have standing to sue. Okay? What Vactoran said was that they had no cause of action. That was the first issue in that case. There, this is what he said. They had not identified a specific right that he had allegedly impaired to entitle the children to relief. And this is the court's response to that. Because there is an existence of a right on the part of the petitioners and a duty on the part of the respondent, violation of that duty constitutes a cause of action. So may cause of action sila. But that's not the same as standing. Huh? Cause of action in the court, what you're essentially asking is there a right that has been violated? Standing, you're asking if you were the person who should be here. Are you the person who's supposed to be filing that case? So that's the first issue. Did they have a cause of action? Yes. Next issue. Was it a political question? Court said no. And this is their response. What is involved is enforcement of right vis-a-vis policies already formulated and expressed in legislation. Then it tells us that political question doctrine is no longer the insurmountable obstacle to the exercise of judicial power. So, 2 wins, right, for the petitioners. The cause of action, it is not a political question. Otherwise, the courts will not rule on it. Third issue. Was there an impairment contracts, which is not allowed under the Constitution. No, says the Supreme Court, right? Because a timber license agreement is not a contract. And when when the public interest requires it, it can be canceled by the government. That is not a new decision that goes way back. They have always held that licenses such as a timber license agreement are not protected by the non-impairment clause of the Constitution. See? So you have three issues, all of which were decided in favor of the petitioners, and yet you can discuss the entire case without making any reference to standing, because it wasn't an issue. Hey. Oposa himself, Tony, just get it out of the way. I'm not angry at Tony. I love Tony Oposa. I think he's an incredible human being. I just disagree with the case, that's all. Okay? Oposa didn't even think that his case was going to solve the problems of the world. In his view, it was meant to spark an interest in environmental protection, to highlight the problems that we are in fact facing. Okay, so he never said this was the magic pill that was going to solve all our problems. Next, and I don't disagree, I'm sorry. I'm not saying that Oposa is useless. According to one author, we see here, the value of Oposa might be the aspirational nature of its ruling. Look at this, the language is biblical. How can you say no to that? It sets out as a goal as necessary in our time as the ever-elusive concept of justice and peace. Like a prophet, it states a thesis and then leaves it to others to figure out. See? Even my students, even when I tell them, Oposa doesn't say anything about standing, they say, yes, sir, but still. It's inspiring. They don't, and I agree, it is. But as a technician, but as a law professor, my duty is to point out the weaknesses of that case. Although, if Tony, I hope he lives forever, because we need people like him. I hope, I hope he continues to rattle, right, jurisprudence and try to improve the environment. Right. So it's not useless. Now, however, I have my opinion is that with the enactment of the RPEC, determination of standing may be irrelevant. Okay? In the rules, it is provided that any Filipino citizen, in representation of others, including minors or generations yet unborn, may file an action to enforce rights. This provision was applied in the case of the marine mammals. We know that? And this is what the court had to say when standing became an issue. The need to give the resident marine mammals legal standing has been eliminated by our rules. In other words, we don't have to decide whether toothed whales, of course mammals have teeth, toothed whales have standing or not. Because as long as you are represented by a person with interest, we don't even have to talk about it. That is the effect of the rules. Right? I mean, you can argue with me and say, yeah, but the rules give everyone standing. That's true, but the way I look at it is, we only have to prove we have standing. Ang importante kasi is that you have someone who has an interest. Then you can represent anybody you want, including generations yet unborn. So we don't have to argue about whether they're standing or not. The other issue is Justice Lonen. That didn't come out right. What I meant is, that doesn't sound right. What I meant is, Justice Lonen has been saying that it's time to review Oposa with the understanding that it binds future generations, and yet we don't know what future generations want. And then, because of res judicata, they might not have standing to challenge actions that we have bound them to today. So in a couple of cases, he's been saying that. And in fact, the first time he said this, he texted me and said, look what I'm doing to Oposa. Okay. He was really excited about it. So it's time to, in his view, is it really a good idea to bind future generations when we don't know what's going to happen in the future? So there's internal hemorrhaging, for lack of a better term. So that's what Oposa is. Exciting, probably not all that necessary. Another reason the environmental community got excited with the Philippine Supreme Court. Let me just say, Justice Velasco has been trying to defend the court's position on the continuing mandamus because there are people who think that, like, according to Justice Nisser, I just promoted him. Sorry, yung mga judges, sorry. It already encroaches upon the functions of other branches of government, particularly the executive branch. And it's not just any person who says that, like me. It's justices who are starting to think that we might have been overreaching on this point. So first of all, there was some lackluster responses from the government agencies in that case, and when the Supreme Court tried to follow up on the resolution, certain justices started to say, wait a minute, I think we may be violating the Constitution. Now, again, I know the introduction of what the Supreme Court says in Padre Faura will have consequences and potentially good effects on the ground. Okay? But more internal hemorrhaging from within the Supreme Court. Look, we're not killing it yet, we're just saying it's happening. Writ of Kalikasan, you know this from the Rules of Procedure for Environmental Cases, which features all of these. Right? Citizen suits, consent decrees, environmental protection orders, writ of kalikasan, writ of continuing mandamus, SLAP suits, precautionary principle. Something to be proud of, by all means, of course, my God. You know, to provide for these remedies for the protection of the environment. That cannot be a bad thing. That's always a good thing. And what essentially is the writ of kalikasan? Well, it's available when the environmental damage is of such magnitude that it prejudices the life, health, or property of inhabitants in 2 or more cities or provinces. It is issued either by the Supreme Court or Court of Appeals within 3 days after the filing of the application. So it's a fast-track method for protecting the environment for emergencies of such magnitude, right? The proceedings terminate within 60 days from the submission of the original application. We looked at the existing cases on writ of kalikasan. Records not so good. Here are our findings of the 17 Supreme Court cases related to the writ of kalikasan. 10 cases were dismissed due to the failure of the plaintiffs to provide evidence to prove the presence of all the requisites for the issuance of the writ of kalikasan. That's 58.82. So at the outset, failing to meet the requirements. All three, in 3 of the 10 cases dismissed, the Supreme Court made clear that mere allegations of the unlawful act or the environmental damage are insufficient. The presentation of expert testimony is not enough. In Segovia, the court said, apart from adducing expert testimony on the adverse effects of air pollution on public health, the petitioners did not go beyond mere allegation in establishing the unlawful acts or omissions on the part of the public respondents that have a causal link or reasonable connection to the actual or threatened violation of the constitutional right. In LNL Archipelago Minerals Incorporated versus Agham Party List, the court said, it is well settled that a party claiming the privilege of the issuance of the writ of kalikasan has to show that a law, rule, or regulation was violated or would be violated. And in that case, the allegation by Agham that the revised Forestry Code and the Philippine Mining Act were violated was not adequately substantiated by Agham. So even the facts submitted by Agham to establish environmental damage were mere general allegations. So it requires a lot of preparation. Imagine, it's an emergency, right? But you have to have all the science to be able to convince the court that this, in fact, requires intervention on the part of the judiciary. But if you go through the cases, it can be disheartening. Plus, for example, in 20% of the cases that were dismissed, the court reiterated that the writ of kalikasan should only be resorted to after other legal, political, and administrative remedies have been exhausted. So it's an emergency, but you have to exhaust your administrative remedies first. Isn't that kind of confusing? Emergency nga eh. I would be even more candid if Justice Tuna wasn't here. I have to behave myself. So this is me behaving myself. Diba? But you know how long exhaustion of administrative remedies can take. We know that. We're lawyers here. That takes forever. If there's an issue with the environmental compliance certificate, then you question the environmental compliance certificate. You don't go to the writ of kalikasan. And then but they are proceeding with the project. So you get all these kinds of cases, and of course, we get concerned about how effective this remedy can be. In most of the cases, 70.5% both dismissed and approved. The court cited administrative reports and findings as the basis for the ruling. Not the testimony, not the scientific evidence. And of course, I imagine the DNR, no offense, of course, you justify your performance. We're following the ECC, for example. We have conducted consultations. So if you do all of that, then the citizens will have a difficult time challenging your actions. I mean, good for you. We're all on the same side here. And stuff like that. There's more. When the paper is finished, I will circulate it, of course. Tagal. Kasi baliktad. So. You must be ready with your evidence when you're filing. So good luck, diba? I mean, let's face it, if it's an environmental crisis, if it's an emergency, I don't know how quickly you can act to gather all the evidence to convince the court that the writ of kalikasan should be issued. Well, of course we're losing. This is how the court looks at your petition. Hasty, slipshod petitions, filed in the guise of environmental advocacy, only serve to undermine their advocacy. So if you're not ready, they'll call you names. Ay, writ of kalikasan should only be availed in extraordinary circumstances that require the immediate attention of the court, and cannot be arbitrarily invoked when remedies are available in administrative agencies. Okay. I already mentioned this. Right? So if you have a problem with the ECC, it's subject of an appeal. You don't go to the court and ask for a writ of kalikasan. You appeal the issuance of the ECC. And that, of course, again, will take time. Now, I'm biased, of course. Of course, we have to balance everybody's stake, all the concerns of all the stakeholders, but my bias is for the protection of the environment, especially in emergencies. So if I sound biased, that's because I am. That's it. Now, we have recommendations, but I think the Chief Justice will discuss that later. So, I appreciate the efforts of the Supreme Court. I admire the fact that we can rattle, environmental litigation. You see, in the 90s, if you don't know, especially those of you are young, lawyers were actually sitting around wondering, what can we do to protect the penguins in Antarctica? Penguins in general. When nobody lives there. And that's where creative solutions came in. And that's why Tony Posa, and another reason why I love him, is because he had the temerity to actually implement some of those ideas that we were throwing around. What if we argue that we're standing to sue for future generations? He didn't just talk about it, he actually filed the case and got the discussion going. Okay? But apparently, from what I've seen, I think the judiciary needs a lot of help. I think the judiciary needs a lot of help, and I think the entire machinery of government should participate in trying to protect the environment. I think in one of our conversations with the Chief Justice, he said the court was compelled to take these steps because there was an absence of initiative from Congress, for example. Absence of initiative from the president, who can always, we know the president can always get Congress to do what he wants, right? What she wants. That's the way the system works. They'll do anything that the president asks. So you need a president who actually has a concern for the environment. So we can start talking about these issues. And I look forward to talking with the rest of you about these issues at a later time today. Thank you. Thank you very much.